Good evening to the participants of the All India Bar examination, those who completed on 5th the examination, and today is the deliberations of the questions, how they are framed, and how much that you got benefited out of it. First, I would like to hear from you. Speak.
సార్ ఎగ్జామ్ బాగానే ఇచ్చారు సార్, ఈజీగానే ఉంది, బాగానే రాశాం సార్. మీ కోచింగ్ బాగా ఉపయోగపడింది మాకు.
వెరీ గుడ్.
ఈచ్ అండ్ ఎవ్రీ సబ్జెక్ట్ లోంచి మీరు చెప్పిన దీనికి బాగానే వచ్చినాయండి, చేయగలిగినాం సార్ ఫ్రీగా.
Those who could watch my videos and mostly participate my videos, they never fail.
Yes,
okay,
sir.
now let us come to our point. The first question, I don't know whether I think it's a set A, is it not?
Sir, I have sent you the full 100 questions of set D, sir. I have sent you the full Word document, sir.
Pardon?
This is set C, sir.
Sir, you can check your WhatsApp, sir. I have sent you the entire 100 questions of set D in Word document.
This is set C. Just now, because...
This is set C, sir.
Yeah. No
Right,
matter,
sir.
no matter. Let me finish this one. Then we'll see that what you have sent. Yeah, because I saw that I'm waiting. Yeah, sir, see the word
No problem, sir.
Yeah, I saw it. Again, I have to drag to it.
It has all the 100
this one
questions.
Meanwhile, let me finish this one, then we'll go to that point. Because again, I have to download to my computer, then we have to make it out. Doesn't matter. Only the questions are jumbled manner. Set A, either is the one, in the B, it may be the 2 or 10 or 12. It is in jumbled manner would be there. But in any case, the same questions are there. Am I right?
Right, sir.
In 100 question, might be the order may be the jumbled. Set A, set B, and set C, and set D. But the questions are the same. So let us see that Sapinda relationship between. So I am sure that everyone can edit that this, because, and I believe that we discussed it earlier also this point. So what is the right answer for this ABCD? Participants, I give the feedback also here.
Answer A
Other
is
side?
right answer, sir.
Mother side 3 generation, father side
Fifth generation.
5 generation.
Option B, sir.
Yeah, then Sabinda relationships are prohibited under the Hindu marriage law. A Sabinda is someone who is within or has a common ancestor relative within 3 generations above you or on your mother's side of the family, within or has a common ancestor relative within 5 generations above you on your father's side of the family. So that is the right answer is, everybody knows it's 3 generations mother and 5 generations father. So the right answer is B. The second question, which of the following is not ground of, say not ground, please note the point, not ground of divorce in the Hindu Marriage Act. And there he has a mental disorder. Yes, mental disorder, it may be a ground. Yes. Venereal disease in communicable form, yes, like HIV, VDC, and incurable unsound mind, and the living separately for less than 3 months. Can you make it the living separately for less than 3 months is the ground?
Yes.
No,
How much?
not a ground.
Desertion, how much?
7 years.
That is
What 7 years? 7 years means presumption of death.
3 years.
No, desertion consecutively 2 years enough.
Okay, sir.
2 years.
Consecutive 2 years is enough for the desertion. So here, not ground for the divorce means only the D is the answer. Am I right?
Yes, sir.
Yes, sir.
Because mental disorder is a ground. Venerable disease and communicable form is a ground. Incurable unsound mind is a ground. So what is not the ground is the D. And because in the section 13 they said judicial separation, incurable of unsound mind is there. Yes, either you say that judicial separation or you can say divorce. Both leads to the same goal. So the right answer for this question is D. Am I right? Yeah. Of course, here I found some other grounds for decision within the purview of the Hindu Marriage Act 1955. Is I need not go through that one because let me see the first questions because I downloaded some of them here. Let me go to the next question is third
క్రిస్టియన్
question.
డీనా సార్
Yeah, third question is Indian Christian can obtain the divorce under which of the following enactment? They say, oh, Vivek, mute. Vivek, mute. I am getting the sound from you. Vivek, mute. Yes, thank you.
Muted.
Yes, thank you. So, Indian Christian can obtain the divorce. I say, Indian Christian obtain the divorce. Please note the point. Under which of the following enactment? Divorce. Special Marriage Act 1954, Indian Divorce Act 1868, Christian Marriage Act 1872, Special Marriage Act of 1872. What did you take it?
Christian Marriage Act 1872.
So, it is a divorce. If you see the feedback, the British India government enacted the Indian Succession Act in 1865, which was to apply the cases of Christians. This act was later replaced by the Indian Succession Act of 1925. Are you getting the point? Which currently governs the inheritance in the case of Christians. Indian Succession Act is for the inheritance. But the divorce is there is a separate act is there, Indian Divorce Act. Yeah, no, it is not correct. For Christians,
Correct, sir.
earlier we used to say Christian Divorce Act, but now we can say Indian Divorce Act. Because Special Marriage Act, irrespective of the caste, it would be there. And the Christian Marriage Act is for the marriage. Am I right?
రైట్ సార్
So what is the right answer you take it here?
ఇండియన్ డివోర్స్ యాక్ట్
Yes, that is the answer for that one. Inheritance, when you ask, then we can say Indian Succession Act will be applicable. Is it clear?
ఎస్ సార్
The fourth, here say, the section 12 of the Hindu Marriage, Maintenance and Adoption Act 1956 deals with, say, Maintenance and Adoption Act. They give the option A, right of adoptive parents to dispose of their properties, B, effect of the adoption, C, presumption as to the document relating to the adoption, D, cancellation of adoption. So what did you take it?
ఎఫెక్ట్స్ ఆఫ్ అడాప్షన్
It's an adoptive father and mother, all purpose effect from the date of adoption. See here I give the highlighted here. Means which is the right answer?
Option B, sir.
Option B is the right answer. Why you are taking so much time?
ఓకే
Why you are taking so much time to give the answer? And next question, if you happen to see which of the following categories of cases will not entertained as PIL? Family pension, petition from riot victims, neglected children, landlord and tenant matters.
D.
ల్యాండ్లార్డ్ అండ్ టెనెంట్ మ్యాటర్స్
But they mention also, they mention, see, it is a controversial. Actually, they are not supposed to give the controversial. But the Supreme Court has issued, but they have to say what the Supreme Court has issued in the recent judgment. Then we can say that Supreme Court has issued a set of PAL guidelines according to which the following matters will not be allowed as PALs. Number one, landlord and tenant matters and service matters, matters pertaining to the pension and gratuity. See, the family pension is there. Is it not the disputed one?
Yes, sir.
They have to give the question. The Supreme Court recently has given the judgment on which point it is not considered as a PAL. Then this is exactly the answer. But it also says that matters pertaining to the pension and gratuity, even service matter also cannot be dealt under the PAL. So some people might be made family pension, but nobody will make the petition from the right victims and neglected children, but they do maintain the landlord and tenant matter. For a time being, we can say that landlord and tenant matter, but one can question it that, sir, family pension also comes over there, and hence it's a controversial. You can write to the Bar Council of India by mentioning your number and so and so thing, write to them. Okay, who is not, this is a very easy question. Who is known as the father of the PAL? We discussed this recently also. What is the answer?
Chandrachud.
Why goodness?
Justice Bhagwati, P.N. Bhagwati.
రామాయణం మొత్తం విన్న తర్వాత రావణికి సీత ఏం కావాలన్నట్టు అయిపోయింది కథ ఇప్పుడు. We discussed in the recently also this thing. I told you the father of the PAL is Justice Bhagwati. Justice Bhagwati has been called the father of the public interest litigation in India due to his contribution to the public interest litigation jurisprudence. Justice Bhagwati was the Chief Justice of India from July 12, 1985 to December 20th, 1986. Mishimiwa. See, I use the Kiswahili. Mishimiwa means my honorable. It's generally they call in the Tanzania Mishimiwa means for parliamentarians and the people. They will call the addressing word. So the right answer is Justice P.N. Bhagwati. Is it clear?
Sir.
Yes, sir.
Yes, now the seventh question they made, procedure Muslim woman has option to be governed by the provision of the section 125 to 120 of the Criminal Code 1973, which section of the Muslim Women Protection Right and on Divorce Act 1986 deals with it? Section 5, Section 6, Section 7, none of the above.
Section 5, sir. Section 5.
5.
To my knowledge, let us see all the sections. See here the section 3 of the Muslim Women Protection Act I have given. It is an order within 1 month of the due date of the filing the application, directing the former husband to pay the reasonable and fair provisions, maintenance to divorced women he has determined as fit and proper, having the regard to the needs of the divorced women. But I checked. Now let us check it. Of course, there is 3 is not there. Now let us see the section 5. You said section 5, is it?
Yes, sir.
Yes, sir.
Let me check it. Section 5 of the Muslim Women Dissolution of Marriage. Right to dower not to be affected. 5. Nothing contained in this act shall affect any right which a married woman may have under the Muslim law to her dower or any part thereof on the dissolution of marriage. This is speaking about the dower. But what is our question? Question is, Muslim woman has the option to be governed by the provision of the section 125. 125 to 128 deals about the maintenance. Am I right?
Yes, sir.
Maintenance of the children, maintenance of herself, maintenance of the dependents. So which section of the Muslim Women Protection on Divorce Act 1986 deals with? But you say section 5. But section 5 is a different matter. Right to dower it is. Right to dower not to be affected. Now let us see the section 6 also. I will give you the answer. Section 6 of the Muslim women, yes, dissolution of marriage. Where it is gone? Just a minute, because it is buffering. Now it is gone. Checking the secured connection. Connection is there. Section 6 is here. Let us see. An act to consolidate clarify the Muslim law relating to the suit and marriages, Dissolution of Marriage Act 1939, 7th section, let you say here, section 7 is here, let you say what it says. Section 7 is about talaq. So now let us see the
None of
section
these.
5. It's about the maintenance. Yeah, it is buffering. Wait. See, here it is.
Namaste, sir.
Look at it. Namaste. Hear me. Grounds for the divorce for the resolution of marriage is given. Notice to be served the heirs of the husband is given. Effect of conversion to another faith is given. Right to dowry is given. And 6 is repealed. Which is the right answer here? You say 5, 6, 7, 8. Nothing is there.
None of this.
None of these. Because I checked it. 5 I checked it. 6 I checked it. 7 I checked it. But there is no such a recurrent provision is there. So
No, there is, sir, actually. That there is, sir.
Shivashankar, yes, please tell me.
Good evening, sir.
Please speak.
Yeah, 1 minute, sir.
Okay, doesn't matter.
Please, sir.
You can adjust yourself meanwhile. I will go to the another question. So 8th question, which of the following is not a ground of void marriage under section 11 of the Hindu Marriage Act? They say A, bigamy, B, degree of prohibited relationship, C, subinter relationship, D, child marriage. Not ground for, please note the point, negative, not ground for void marriage. So here it is given a marriage solemnity between the two Hindus, including the Buddhist, Jain and Sikhs, is void if the party had a husband or a wife living at the time of the marriage and subject to the provision of the 494-495 Indian Penal Code. So it deals about the bigamy, if it is. So bigamy is one of the ground. Of course, prohibited relationship, naturally it will not be done. Then Sapinda, child marriages, yes, it can be made. You are right? Under section 11. Under section 11 of the Marriage Act, suppose what are the grounds are there for the under section 7 it is given, let us see it so that we could know
B is right answer.
which one is the right answer for that one.
B.
Child marriage, sir.
Yeah, but let you confirm it. Let me confirm. If you see the section total line, see 11, any child of such marriage who have been legitimate if the marriage had been valid shall be legitimate. Whatever such a child is born before or after the commencement of the marriage amendment 1978. Then section 11, if you happen to see the total section, and we can understand the clear-cut manner what is what. See, the section 11 is gave void marriages. Any marriage solemnized after the commencement of this act shall be null and void, may, on the petition presented by the either party there against the other party to be declared to be a decree of the nullity, it contravenes one of the following specified clauses. That is 1, 4 and 5 clauses should be there. So the question is not ground. The question is not
Ground.
a ground of valid marriage. But definitely ground for valid marriage is the following ground of the void marriage is bigamy, degree of prohibited relationship, subinter relationship. So now it is only the choice we can choose. Am I right?
Basically,
Yes, sir.
child marriage is voidable marriage, sir.
Yes.
Child marriage is wide, na sir. Wideable.
Voidable. That is not section 11. That is next one, section 12.
No, what do you say
It is
here?
prohibited in
Which
the
option that you will
relationship,
say
sir.
that?
Option D, sir. Child marriage is the right answer.
D is right answer, sir.
Child marriage, sir.
Yes, I am saying the same which I highlighted there. Then where is the dispute?
Yeah.
No, where is the dispute? Tell me.
Somebody was saying B, sir.
There is no dispute. Okay. Which of the following writ? I think it's a very easy question it is.
Yes, sir.
For the against the usurpation of the public office, any person just having a little knowledge can say that, sir, it is a quo warranto. Am I right?
Yes. Yes, sir.
The writ of the quo warranto is used to prevent illegal assumption of any public office or usurpation of any public office by anybody. So both the way we can ask them in what capacity quo warranto is them. Then the Ridge versus Baldwin case law deals with corporation, natural justice, state liability, delegated legislation.
Natural justice.
Justice, sir.
I think, did we discuss this case law? In the natural justice. Let me check it.
Yes, sir.
Because to my knowledge, I think I read it this case law. See, Ridge versus Baldwin case, it is clearly says, is a UK labor law case heard by the House of Lords. The decision extends to the doctrine of natural justice. Yes, is the procedure, fairness should be followed over there. So you are very much rightly suited for this question. Because he asked the landmark case law also here. So that's why we should have to, we dealt many landmark case law, including the foreign case laws, I mean the English case laws. This is, I don't think that anybody would commit a mistake here. 11th question. Am I right?
Yes, sir. Option. Yes, sir. Option A, sir.
When you are going to punish any person, please give the chance to him or her to speak first. So that is the natural justice, adi alteram partem. So the right answer is
Option A.
option A person cannot be condemned without being heard. Of course, an adjudicating authority must give a speaking order. No man can be a judge in his own. These are all they fabricated. So the right answer is A for that one, because we discussed it also in the class, earlier classes, adi alteram partem. Then the rules made by the Bar Council of India is exercising its rules making power under the Advocates Act, under the Advocates Act. Oh, I am sure that we can it out. Am I right?
Yes, sir. Option C. And
Yeah, because on that day we discussed this act number also we did it on that day when we were discussing the things. Yeah, when you speak at the time you unmute it. You don't speak, you mute it, unless until there is no disturbance from your house and you are alone in the house. You can unmute it no matter, because now the 13th question: an advocate may, while practicing, take up teaching of law in any educational institution which is affiliated to
3 hours.
university, so long as the hours during which he is so engaged in teaching of law don't exceed hours in a day. Advocate, he can teach it. I think it is 3 hours. It's
3 hours.
Yeah, man.
3 hours, sir.
Because
Anis
suddenly,
case. Anis Ahmed.
there is a rule is there. Any subject could be taught 3 hours in a week. So each day 1 hour we can teach. Or ATS test 3 hours we can teach. But ATS test they don't allow it. UGC will not allow it. Because you have to give the dose in a proper proportionate manner. If you give the medicine also in a bigger dose, the medicine become a poison. Am I right?
Yes, sir.
So 3 hours is the right answer. It is given Anisa Kesla.
Anis Ahmad.
Very good, very good. I appreciate. So, in which of the following landmark case the advocate has held guilty of the professional misconduct and he had forged the court order forging? Oh, this we did not delete. Pratap Narayan versus YP Raheja and Vikramaditya versus Srimati Jamila Khatun, Babu Lal Jain versus Subhash Jain, Srimati Pankajam versus B. Chandrasekhar. To my knowledge, it may the D answer.
Don't know,
How
sir.
did you make it out?
Pratap Narayan versus YP Raheja.
Let me check it. Let me check it. Because this we did not cover it. Okay, because we need not to cover everything. We can get easily 40 marks. Excuse me. And here the fact and issue are cases here. Professional misconduct by a lawyer in India. Yeah, you are right. Here it is given, it seems. Yeah.
Right answer, sir.
Let us see it. Misconduct where it is given. The under Advocates 1966? No, 1961, the Advocate Act. Tulsidas Sammal, P.D. Gupta, Allahabad, Krishnarajan, Srimati, Surendranath Mittal, Pratap Narayan versus Raheja. In this case, the complainant alleged that the respondent handed over him a forged stay order. Yes. While so stay order was passed by the court in the case. Yes. Respondent, however, pleaded that the forged stay order was handed over to the complainant by his. So, right answer is Pratap Narayan versus YP Raheja. Is it clear?
Sir.
So no doubt at all. So those who shooted it, whereas even I could not able to shoot also. I was in the impression that Pankarajam versus Chandrasekhar. Okay, 15th question. The which of the following is not a real purpose of public interest litigation? Okay. A. Vindication of the rule of law. B. Facilitate the effective access to justice. C. Meaningful realization of the fundamental rights. And the getting famous and making wealth. We can eliminate this D. Yeah, am I right?
Yes, sir.
Vindication
Yes,
of the rule of law. No, we cannot vindication of the rule of law. If any person make the change it there we can make it out. And so meaningful realization of the fundamental right. Yes, if anybody fundamental rights are violated over there, yes, we can file a case on behalf of him. Am I right? Not here, say not real. Not real
Option
means
D, sir.
generally out of the A, B, C, D, we can choose it.
D, sir.
D, we can choose it. Because they say not. So please, people will not forget it about not. And they will say, sir, this is the right. No, not. So perhaps here, among all the things, appropriate is very D. Am I right?
Yes, sir.
You should not make any assumption and presumption. Please, note the point. If any assumption and presumptions are there, okay, you can write in a letter to the BCI. But you have to shoot which is given over there option. Oh, Hussain-AIBE Khatun State of BR. Yes, I believe that everybody did it. Am I right?
Option B, sir. Right to free legal aid.
Or speedy justice.
Speedy justice.
It is a speedy justice. See, it is the first case law where the PIL is fair. Of course, this is the right to a clean environment also there, but a major part of it is Hussain-AIBE Khatun. Hussain-AIBE major part, what I want to say is, the speedy justice should be given. Of course, it goes with the cleanliness also. It goes with the cleanliness also, no doubt. Because prison areas are not clean, hygienic there. But many under-trial prisons are lagging behind there. So Hussain-AIBE, that is the Honorable Supreme Court of India held that the state cannot deny the constitutional right of speedy trial. See? Speedy trial and the equal access justice. So it is the first case like the PIL. It is about the speedy justice also. So the right answer for this one is speedy justice. Is it clear? Undisputed.
Yes, yes.
Okay, doctrine of lifting of piercing. This is also a very easy question. It's associated with the Any person can make it out. Yes?
That's company law, sir.
Company law. What is the Salman versus Salman? It's a classical case law. Yeah, the 18th question, under which section of the Environment Protection Act 1986 an appeal to a National Green Tribunal entity lies? Okay.
Section
Yeah,
5.
myself also did not know the
Section
answer.
5A.
But I can shoot it out of 4, 5, 6, 7, 5, 6. I think B is the right answer.
Yes, sir.
Is it?
Yes.
See, I even to be frank, I don't know this answer. But to my earlier teaching gives the sense to me, perhaps the B is the right answer. I need not to check again.
No need, sir.
Okay. Now that is the answer. B is the right answer. Okay. Which one is the following fundamental duties related to the environmental protection duties? Fundamental duties relating to the environmental protection. Yes, even I myself
B,
also
sir.
did not know it.
Option
Answer B. B. Option B.
Option B,
B.
here, G. That is the 51 capital
G.
A and small g.
Yes, sir. G.
Even myself also did not know it. Perhaps I would have to shoot the different answer because I was thinking this is the answer. I was in the impression. Okay, G is the right answer. 51A, G. Yeah, we did not cover it, but we can shoot it by using our own technique. So, Mr. A, who was aggrieved by an order made by the controller or an educating officer, made an appeal with the Cyber Appellate Tribunal. Later, Mr. A, aggrieved by the order of the Cyber Appellate Tribunal, may prefer an appeal. See, generally, a tribunal after, can we go to the High Court? Can we go to the Supreme Court?
High Court.
High Court, sir.
It is the High Court only. So I'm
Right.
sure that it is only the High Court. Am I right?
Yes, sir.
Yes,
Because tribunal is equivalent to the High Court. Not equivalent in general. In general, not
Magistrate
equivalent in general. But we can apply to the, but only central tribunal is concerned. At the time, I don't think that there is any court is having jurisdiction, except the Supreme Court. But anyway, that our students may shoot it very clear manner in this one. Okay, now let us see the Mr. X, a person who is intended by Mr. Y and an originator to receive the electronic record is under the IT Act as known as intermediary,
Option C, sir.
original agent, addressee,
Addressee.
keyholder.
Addressee.
Addressee, sir.
Addressee.
Is it?
Option C.
A person
Yes, sir.
intended addressee. Can we say addressee? Because generally, sender, a person who sends, receiver is addressee. Am I right?
Yes, sir.
Can we test it or need not to test?
Yeah, we have checked it, sir, in the Bear Act. It was given addressee.
Okay. So address is the right answer.
Sir.
I think many of the students might have shooted this addressee. Am I right?
Yes.
Because generally they will apply it to the mind and they make it out. So 22nd question, the minimum number of the members required for the registration of trade union.
7.
7, sir.
I'm sure that nobody has committed a mistake here.
So, direct question, sir.
If it is a dacoity,
More than 5, sir.
more than 5. Or 5 or more than 5. Is it
Yes,
not?
sir.
So 23rd question, if any advocate is aggrieved by an order of the disciplinary committee of a state bar council made under section 35 of the Advocates Act, or Advocate General of the state may prefer an appeal to the Bar Council of India within generally 30 days, 60 days.
60 days, sir.
60.
Yeah, because only two options are there, either 30 or 60. Okay, I believe the
60,
student
sir.
might have shooted rightly. Okay,
we have
very
referred
good,
Bear Act,
very
sir.
good. And 24th, ABC Private Limited Company choose to convert itself into a public company. Okay, good. A private company into the public company. It can do so by altering the memorandum of association and articles of association by passing ordinary resolution, special resolution, board resolution, none of the above. I think
Special.
special resolution.
Board resolution, sir.
No, sir.
Even myself also don't know the answer. This one.
Okay, sir.
Board resolution, sir.
It's a board resolution. Okay.
No, sir. Doubtful, sir. Doubtful.
Doubtful,
No,
sir.
why
Why
not?
Sir,
We
it
can
is
check
special
it now.
resolution, sir.
No
The correct
matter.
answer is special resolution.
We can check it now. It is give the answer. Why you are? We should go with because we are here now to make it दूध का दूध पानी का पानी. Am I right?
Yes,
See,
sir.
conversion of the private company to the public company here. Conversion of the private company to the public company. Alteration of the article has been by passing the special resolution. I am right.
Special resolution. Special resolution.
Right, sir. I am right, sir.
At least I got the one point because I shooted this one first by special resolution.
నాకు కూడా వస్తుంది సార్ 1 point.
Yeah. Okay, if the factory has more than 1,000 workers, okay, they should appoint qualified dash carry out the prescribed duties. Safety officer, I think it's a welfare officer.
వెల్ఫేర్ ఆఫీసర్ సార్.
It's a welfare officer, not safety officer. Safety officer for the fire. Yeah, am I right?
సేఫ్టీ ఆఫీసర్ అబౌవ్ 50 ఏమే అపాయింట్ సార్ 500.
Who? No, what is the right point here?
Sir, safety officer only we have.
వెల్ఫేర్ ఆఫీసర్ సార్.
Sir, check it.
Sir, I told you welfare
Why
officer.
we should have to worry? To my knowledge, I am contention that welfare officer.
No,
Yes, sir.
sir, safety.
Yes, to my knowledge,
Welfare officer.
because in the Singareni colliery is the safety officer in the underground, welfare officer in the on the surface. Of course, he will take both the actions.
Safety officer only.
Is it? Let me check it. Carried out. Is it running?
వెల్ఫేర్ ఆఫీసర్ సార్.
No, let it go. Why we should have to go? See here, if the factory has more than 100 workers, they should appoint a qualified dash carry out the prescribed safety officer. No, you are the safety officer
Yes.
in a general condition, and the safety officer should be employed where 1,000 worker. Oh, I failed. Safety officer. It's good. Yeah, because sometimes such tricky questions are there. Very good question. You paint very nicely. So suppose the road accident occurs, then being an advocate, what is the correct way for approaching the situation? What is the correct way means either you are advocate or you are a common man. You have to go to the police station first. Am I right?
Summons to insurance company.
Yes. Generally, you have to inform to the first you go to the police station, then from there you have to inform to the insurance company because it is the insurance company come to your rescue. Am I right? Or can we check?
ఫస్ట్ పిటిషన్.
Yeah, petition. No, first we can make the petition to the police station. Immediately we can write to the insurance company. Let me check it. Yeah. Who is the first thing to do when approaching the scene of accident? What are the 5 steps? No. Accident to the road. Traffic police. First we have to make a application to the police station. Then we can write to the road safety, child safety. No, they say at the time, consequently roads are pedestrian safety and cyclist, drivers. No, let me check again the question first. Suppose road accident occurs. Then, being an advocate, what is the correct way of approaching the situation? So, FIR
Option D.
petition, summons to the insurance, petition FIR, summons to the insurance company, summons to the insurance company, petition FIR, FIR, summon insurance company, petition. Acha, these are the, here, do you know that there are 3 steps are there? Did you observe the steps? First is FIR, petition, summons to insurance company. Then another is petition, FIR, summons to insurance company. Then summons to
Correct, sir.
insurance company, petition and FIR. FIR, summons to insurance company, petition.
B is right answer. B. First
D.
petition,
D.
then FIR, then summons to insurance company.
Can't you go to the police station at the time of the accident? That's my question.
Sir, I have written petition FIR summon to insurance company, sir.
First
Yes, sir, I
FIR
have
should be written.
Yes,
First
sir,
FIR, sir. Police station, after going to police station, we will get it. FIR only.
FIR,
No, sir,
cognizant
because-
offenses, first FIR comes first.
Yes,
Sir,
FIR
sir.
before filing FIR, we have to give petition only, then only they
Acha,
file
acha.
FIR.
First petition, next FIR, next summons to the insurance company. Yeah,
Yes,
yeah.
sir.
Sequences, yeah.
I have shooted
No,
like
sir.
that, sir.
No, sir. First, we have to collect the FIR. Then only we can file the petition in the court, suit in the court.
So
No,
petition,
sir,
how can we say that petition?
See,
before giving
complainant,
petition,
a
how they will file
complainant
the
should
FIR?
have given the application first to the police station.
Yes.
So, whether call the
Sir, here-
application or petition. What do you say, right terminology?
సార్ పిటిషన్ ఓన్లీ విల్ సే
Sir.
వాళ్ళు పోలీస్ స్టేషన్ పోగానే మీ పిటిషన్ ఇవ్వండి మేము ఎట్లా ఎఫ్ఐఆర్ కడతామంటారు
Oh, sir.
Acha,
this
acha,
is a-
acha, acha. So, the what is the
What is the-
petition?
Procedure to advocate, sir. This is not.
Sir, this is actually to
Okay,
advocate,
okay.
sir. That is the
మీరు
question.
పిటిషన్ ఏంటి ముందుగాల అంటాడు. ఓకే, మీరు పిటిషన్ ఏంటి సార్? మేము ఎఫ్ఐఆర్ ఇష్యూ చేస్తాము.
ఎట్లా చేస్తాము అంటారు
అయితే
Sir,
ఆన్సర్
sir.
బి ఇస్ ద రైట్ ఆన్సర్.
Sir, can I speak, sir? Sir, hello.
ఎస్.
B is right answer, sir.
Sir, no, sir. The right answer is A. First thing.
Yes, sir.
Okay.
Yes, sir.
Sir,
A is
the
the right
reason
answer, sir.
sir, can I'll just explain, sir. Here
Yeah.
we all assume petition means the application that we give in the police station about of a complaint.
Yes.
That is not. Petition here is the stands for the petition that we make in the court, sir, for
Okay.
for the compensation, sir. Okay.
Okay.
So that is the petition.
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।